Aspects of banking. The first question is, which of the following can be classified as a commercial tax? Income tax, professional tax, wealth tax, estate tax, sales tax. We start with actually we took up the next page. We start from the first question, first page, whiteboard 1. Which of the following statements is false in respect of a company registered under the Companies Act? The correct answer is B. The company enjoys rights and liabilities which are not the same as that of its members. Being a distinct legal entity, the company has the capacity to sue and be sued. The members of a limited company are only liable to contribute towards payment of its debt to a limited extent. The wealth of the shareholders and the wealth of the company are not the same, they are separate. An incorporated company's wealth is clearly distinguished from that of its members. Therefore, it is wrong to suggest that the company enjoys rights and liabilities that are the same as that of the members. Therefore, B is the correct answer. The company does not enjoy the same rights and liabilities as the members. The other statements are correct as we have seen. Next question is, a partnership where every partner has a right to dissolve the firm by giving a notice to all other partners specifying his intention to dissolve the firm is known as. The correct answer is C, that is partnership at will. In case of partnership at will, every partner has a right to dissolve the firm by giving a notice to all the partners specifying his intention to dissolve the firm. The third question is, the mercantile agent who is employed to negotiate and make contracts for the purchase or sale of goods for remuneration is known as, and the answer is D, broker. Broker is the mercantile agent who is employed to negotiate and make contracts for the purchase and sale of goods. He neither has control nor possession of the goods. He serves as a connecting link and tries to bring out a business contract between the principal and the third party. In case the deal materializes, then he receives the commission known as brokerage. Let's move on to the next question. Which of the following agreements is considered voidable under the Contract Act? The correct answer is A. Agreement where consent is obtained by fraud. What is a voidable contract? A contract is voidable when the consent of a party to the contract is obtained by fraud, misrepresentation, coercion, or undue influence. In case of agreements in restraint of marriage, agreements by incompetent parties, agreements with unlawful consideration, and agreements under mutual mistake of fact material to the agreement, the contract is void. Therefore, option A is the correct answer. We move on to whiteboard 2. Suresh, Anuj and Prabhakar entered into a partnership. However, they did not register the partnership. Suresh was aggrieved that although he was the one who was managing the affairs of the firm, he was not given due share of the profits of the firm for his contribution. Hence, he decides to file a civil suit for recovery of profits due from the other partners. Which of the following statements is true in respect of the rights of Suresh to claim the share of profits by way of civil suit? Go through the options. What should be the answer? Just go through them very carefully. So, the correct answer in this case is C. A partner of an unregistered firm cannot sue the firm or any other partner of such firm by way of a civil suit to enforce any right accrued from a contract. That is a partnership deed, that is the contract, or conferred by the Partnership Act. However, the aggrieved partner can institute criminal proceedings against such firm or any of its partners. Civil suit cannot be filed, but the criminal proceedings are not debarred if made out. Therefore, in the given case, Suresh cannot file a suit against other partners as the firm has not been registered. Hence, option C is the correct answer. Let us take the next question. Please go through the question. Anil and Sanjay were business associates. Anil invited Sanjay for dinner at his house on his son's birthday, which was a working day. Sanjay cancelled some of his important business meetings and reached Anil's house on the appointed date and time. However, to his surprise, Sanjay found that Anil's house was locked and the party was cancelled. Which of the following statements is true in respect of the above circumstances? Now read the statements. The answer is E. There is no valid contract as it is a casual agreement between friends. A contract is the result of a promise to do a certain thing in exchange for a promise from another person. Non-business, religious or charitable agreements need not be contracts. Casual agreements between friends and family or household agreements are not held as contracts. Let us move on to the next question. We go to whiteboard 3. Is this clear? Then let's go to whiteboard 3. A kind of charge where goods remain in the possession of the borrower for his use is known as, this is known as, you all know, hypothecation. The transfer of interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan and existing or future debt, or the performance of an engagement which may give rise to pecuniary liability is known as a mortgage. Pledge, you all know. The answer to this question is hypothecation. We go to the next question. The bank in the exporter country which authorizes and forwards the letter of credit to the beneficiary or the exporter without any other commitment is the, what should be the answer? Is the advising bank. The answer is B. The bank in the exporter country which forwards the letter of credit to the beneficiary or the exporter is called the advising bank. The bank which opens the letter of credit on the request of the applicant or buyer is referred to as an issuing or opening or importer's bank. The bank in the beneficiary exporter or exporter country which makes payment on the bills drawn by the seller and accepts the documents is called the negotiating bank. So negotiating bank is the bank in the exporter country which makes payment on the bills by negotiating the bills, where the advising bank, in addition to advising credit to the beneficiary, confirms such credit. Such an advising bank shall be deemed as a confirming bank. The bank appointed by the issuing bank to reimburse the negotiating, paying or confirming bank is known as the reimbursing bank. Right? Do we move on to the next question? The next question is, if in a contract the promisor receives consideration simultaneously with the promise, the consideration in such a case is known as. The answer is B. Present consideration. Consideration may be of three kinds: past consideration, executed or present consideration, and executory or future consideration. Present consideration is an act or forbearance made or suffered or done in relation for a positive promise. In this case, the promisor receives consideration simultaneously with his promise. For example, in a sale by cash, consideration is present or executed. Present consideration is also known as executed consideration. The next question is on tariff. What is tariff? The answer is C. A tariff is a tax imposed on imported products. Tariff increases the price of imported goods in the domestic market. Next question. Arjun Rawat, the owner of a cinema theatre, borrowed money from Citibank by hypothecating his cinema projector and accessories with the bank. The bank allowed the projector and the accessories to remain with Arjun Rawat since they formed the equipment of running a cinema. Later, Arjun Rawat sold the projector and the accessories along with the theatre to another person. Which of the following statements is true in respect of the above circumstances? In hypothecation, the hypothecator holds the goods as an agent and not as the owner. So the borrower holds the goods as an agent and not as the owner. The goods are liable to be returned to the hypothecatee under the circumstances stated in the contract of parties. If the hypothecator refuses to return the goods to the hypothecatee has a right to seek court help in recovering them. The decision of Andhra Pradesh High Court in Bank of Chittor versus Narasimha Lulu is an illustration to explain this principle. A cinema projector and accessories were pledged with the bank. The bank allowed the property to remain with the pledgers since it formed part of the equipment of running a cinema. Subsequently, the pledgers sold the machinery. The court held that the sale was subject to pledge. There was a constructive delivery or delivery by atonement to the bank. So, are we clear? The hypothecator or the borrower who hypothecates goods to the banker is an agent of the bank for holding those goods. The owner is the bank in whose favor the charge has been created. Let us move on to the next question. Whiteboard 4. Mohanlal Jain, the Karta of a Hindu undivided family, manages the business of the HUF. While the HUF business was in a crisis, without consulting other co-partners of the HUF, he raised a loan from a finance company in the name of HUF to stabilize its business. Which of the following statements is true in respect to the repayment of loan? Just go through the options. Let us have your view. Is the HUF liable to pay the loan? The answer is E. The Karta is bestowed with full control over the affairs of the family business and is not questioned on the acts done for the benefit and in the name of the family. Therefore, in the given case, as Mohanlal Jain has taken the loan in the name and for the benefit of HUF, the HUF is liable to repay the loan. Therefore, option E is the correct answer. Next question. Mahesh, a popular magician, enters into a contract with the management of a friend's club to conduct a magic show at the club on 28th October 2008 as a part of the club's Deepavali celebration. Later, Mahesh entered into an agreement with City Hotel to give a performance at the same time and on the same date. Obviously, the venue is different, as they offered a higher remuneration. Which of the following statements is true in respect of our circumstances under the Indian Contract Act 1872? Just go through the option and let us know which statement is true. So the very first statement, Friends Club can file a suit against Mahesh for grant of injunction restraining Mahesh from performing at the City Hotel. That is the right option. An order of injunction makes the guilty party refrain from doing or not doing precisely the act which is causing the breach of contract. Next question. So we go to whiteboard 5. Which of the following can be classified as a commercial tax? Sales tax, VAT, excise duty, customs duty and service tax, etc. come under the category of indirect taxes. These are also known as commercial taxes. Income tax, professional tax, wealth tax and state duty are direct taxes. So the answer is E. Next question says, under the Indian Stamp Act, a demand promissory note that is not duly stamped. What is the position of admission in evidence? Which should be the correct answer? The correct answer is A. It is inadmissible in evidence in a court of law. The following documents, which if unstamped or inadequately stamped, are not at all admissible in evidence. What are these documents which are not admissible in evidence? Demand promissory note, usance bill of exchange, acknowledgement of debt. Except the above documents, all other documents are admissible in evidence even if they are inadequately stamped by paying penalty at the discretion of the collector. So if these three documents, what are the three documents? Demand promissory note, usance bill of exchange and acknowledgement of debt, that is a BC letter. These three documents have to be stamped. If they are not stamped or they are understamped, they will never be visible in evidence and nobody can rectify it. All other documents, if understamped, they can be the duty can be made good by permission of the collector. We go on to the next question. When the party supposed to perform commits default on the stipulated day, the contract becomes void, illegal, valid, unenforceable, voidable at the option of the promisee. So the answer is it becomes voidable at the option of the promisee. When the party supposed to perform commits default on the stipulated date, the contract becomes voidable at the option of the promisee. E is the correct answer. Next question is, when the person to whom a proposal is made signifies his assent thereto, the proposal is said to be accepted. The proposal once accepted is known as, what is it known as? Promise. The proposal which is accepted becomes a promise. According to section 2B of the Contract Act, when the person to whom a proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. Hence, option D is the correct answer. Let us move on to the next page, that is whiteboard 6. Which of the following statements is true in respect of a Hindu undivided family business unit? It consists of heterogeneous members. A co-partner cannot demand partition of the joint family business. A co-partners can contract debts for the purpose of the business. It being a separate legal entity is assessed to tax as a separate person. Registration is compulsory in case the number of members exceed 20. So, which is the correct statement? Which is a true statement? The answer is D. It being a separate legal entity is assessed to tax as a separate person. In case of a Hindu undivided family business unit, a HUF business unit consists of homogeneous members. Since it consists of members of the joint Hindu family, it is not heterogeneous, it is homogeneous. A co-partner can demand partition of the joint family business. So B is also wrong. The Karta has the sole authority to contract debts for the purpose of the business. Other co-partners cannot do so. Not that any co-partners can contract debt. No, only the Karta. A HUF being a separate legal entity is assessed to tax as a separate person. It is eligible for all the deductions and exemptions, including the benefit of basic limit chargeable to tax and wealth tax available to an individual. Registration is not compulsory for carrying business even if the number of members exceed 20. Therefore, the correct answer is D. Next question. Where there is no opportunity of communicating to the concerned parties about an urgency and a person in such a situation acts an agent for the benefit of the other, it is known as. What should be the answer? Go through the options. It is known as agency by necessity. Answer D. When there is no opportunity of communicating to the concerned parties about any urgency and a person in such a situation acts as an agent for the benefit of another, agency by necessity is said to have taken place. That is agency by necessity. Next question says, a situation wherein the offeree changes the terms of offer made by the offerer is known as counter offer. This is known as counter offer. A counter offer is a situation wherein the offeree attempts to change the terms of the offer initially made by the offerer. A counter offer implies the rejection of the original offer. Therefore, option E is the correct answer. Next question. Arun agreed to extend his guarantee for the overdraft facility to be extended by Maharashtra Bank to Gaurav. The credit limit for Gaurav was fixed at 2,50,000 after Arun extended the guarantee. However, 3 months later, the bank reduced the credit limit for Gaurav to rupees 1,50,000 and then again increased it to 2,50,000 without consulting Arun. Which of the following statements is true in respect of the liability of Arun as the surety under the Contract Act? Please go through the options. So the answer is E. The validity of a contract of guarantee will not be affected in case there is a written contract of guarantee and there is no variance of the same in writing. Hence, in the given case, Arun is not discharged from his liability as a surety as there was no variation in the terms of the contract. Overall limit has not been exceeded. Whatever it was there, he is not being held liable for more than that. Next question is, Nandan, who was interested in buying a house for himself in Mumbai, sent a mail to Akash saying, "Will you sell your mud island bungalow to me? Mail the minimum price expected." Akash sent a reply stating, lowest expected price for the bungalow is between rupees 2 crores to 2.5 crores. In reply to this mail, Nandan stated by mail, "I agree to buy the bungalow for rupees 2 crore. Please arrange for registration of the title deeds of the bungalow. Which of the following statements is true in respect of the above circumstances?" Please go through the options. An agreement presupposes an offer by one party which is accepted by another party. Therefore, one without the other does not bring an agreement into existence which can be legally enforced. Mere offer does not conclude a contract. It is in this aspect that the distinction is sought to be made between an offer and an invitation to offer. Offer and invitation to offer. There must be a lawful offer and a lawful acceptance for a valid contract. An offer is distinguished from auctions, price lists or catalogs, price indications and prospects. Therefore, in the given instance, there is no valid contract as the asking of lowest expected price amounts to a price indication as distinguished from offer. Hence, option D is the correct answer. There is no valid contract as the inquiry of lowest expected price amounts to a price indication as distinguished from offer. We move on to the next whiteboard 7. A contract by a third party to perform the promise or discharge the liability of a promisor in case of promisor's default to a promisee is known as. What is your answer? The correct answer is C. Contract of indemnity. Sorry, this will be answer is B. The contract of guarantee, not indemnity. Contract by third party to promise to perform the promise or discharge the liability of a promisor in case of promisor's default to the promisee is known as. Section 128 defines contract of guarantee as a contract to perform the promise or discharge the liability of a third person in case of default. So this is section 126, contract of guarantee and not indemnity. Next question. Who among the following persons is disqualified to enter into a valid contract under the Contract Act? Go through the options. The correct answer is E, a convict. All the agreements made by lunatics during lucid intervals are valid. An alien enemy is the citizen of a country that is at war with India. An agreement with an alien enemy is void. After the order of discharge, an insolvent is competent to enter into a contract. Convict is a person disqualified by law to enter into a contract. Next question is, where the mortgagor transfers the possession of the mortgage property to the mortgagee with authorization to receive the rents and profits accruing from the property in lieu of interest or partly in payment of mortgage money. Such type of mortgage is known as. Look at the options. The answer is C, usufructuary mortgage, where the mortgage transfers the possession of the mortgage property to the mortgagee until the payment of the mortgage money and to receive the rents and profits accruing from the property in lieu of interest or partly in payment of the mortgage money. This type of mortgage is known as usufructuary mortgage. Therefore, C is the right option. Next question. A banker is authorized to combine the deposit and loan accounts as there is existence of mutual debts between the bank and the customer. Such right of combining accounts is known as. The answer is set of C, A banker is authorized to combine the accounts in case there is existence of mutual debts between the bank and the customers for the payment of money to each other. Such power of combining accounts is known as set off. We move on to the next whiteboard 8. The question says, under the Contract Act, the use of a relationship of trust and confidence by one party to exploit the other party to derive some contractual advantage is said to amount to. What does it amount to? The answer is undue influence. Option B. Under the Contract Act, the use of a fiduciary relationship of trust and confidence by one party to exploit the other party to derive some contractual advantage is said to amount to undue influence. Move on to the next question. Which of the following is not an essential element of contract? Which is not? Just think about it. Free consent, offer and acceptance, legality of object, certainty and possibility of performance, adequacy of monetary consideration. So the answer is E. The essential elements of a valid contract are free consent, offer and acceptance, capacity, consideration, lawful object, certainty and possibility of performance. Terms of contract should be clear. Agreement must not be declared void. Legal formalities. In a contract, consideration need not be adequate, and in monetary terms, consideration may be an act, abstinence, or forbearance. Therefore, option E is the correct answer. I think with that, we come to end of this session, right? And thank you very much, friends. You can, those of you not been able to attend, can go through the recorded version of the class and try to for the next session try to put your devices properly so that you are able to connect, isn't it? You telephone, but then at that time it was not possible for me to really. Before the class, try and see that your device is in order, the internet speed is okay, you have the headphone installed, this, that and whatnot. With that, we end the chapter on legal aspects of business. This class was additional in addition to the classes we had at the JSS Institute of Banking and Finance. So this was an extra class given to you, and I'm sure this would be beneficial to each one of you. Now we'll be meeting on 1st and 8th of October for the bookkeeping and accounts and finance class. Time will be same, 10 to 5. The venue is the same, the room is the same. Wish you all the best. God bless you. Thank you very much.